Judge, thank you for doing this. I think you've done this more than any other guest we've ever had, so we really appreciate you coming here every year. Take a minute and tell the students a little bit about your background, what led you to law school, what led you to becoming a member of this famous class of 1974. And then we're going to start with the first of your three careers in the law.
Okay. I grew up in Atlanta in the home of a lawyer. My dad, Lamar Sr., was a graduate of this law school in 1948. He was World War II, came back, went to law school. That's a famous class of this law school. If you haven't learned a little bit about it, I'm sure you will as you go through your time here. All of them veterans, World War II, more mature group. My class was a lot like that. It was the Vietnam era. Many of my classmates were Vietnam veterans. A little more mature, a little older, some married with children. Not what otherwise would have been the typical law school class. But I grew up in my dad's home, watching him answer the phone and talk to clients at night, going with him occasionally on Saturdays to the office. He thought so much of his responsibility to his clients, he had a separate phone line put in, and this was back in the 60s. I mean, you just didn't have two lines in your house in the 60s. You might have an extension, but you didn't have a separate telephone line. Well, Dad did, and it rang in his room, your mom's room, and the kids, all teenagers at that stage, could not touch that telephone without permission, because that was for his clients. And they all had his number. And that was before, obviously, the day of cell phones. That's how he would have handled it, I guess, today. But I watched him with his commitment to his clients. I watched him get up early and go to work early, and I watched him come home late, and I watched him go in on Saturdays. Many times he had clients who would fly in from Miami. I remember one client in particular. I remember a senator from Washington that would fly in on Sundays, and Dad would go downtown and meet with him. And I also saw him go sit on the back porch, patio, with the neighbors. Somebody would call and have an issue and want to come by and drink a cup of coffee with him in the evening and talk to him about their legal problem. And I was sort of moved by that, I guess. I was certainly influenced by it. And after graduation and after a little time in the Army, I decided to come back to this law school, of course on the other campus. And I just, by luck, was in the class of 74, which turned out to be a wonderful mix of people who bonded. Smaller groups, easier to do that, easier to have that feel for one another. We graduated, I think, 72 people. We had a reunion every year for 10 years after that on Law Day. Then we've changed it to every 5 years. So we've stayed in touch. We've got to even have a website for our law school class so we can communicate with each other. Lots of time now, since I'm in Macon, I'm usually the one getting the information out. And unfortunately now I find myself sending obituary notices to our classmates. But anyway, I'm glad to be a part of that class. We started a scholarship, and in fact I'm interviewing 2 people after this class for the scholarship for our class.
Of course, your father's portrait hangs on the second floor of this building.
Yeah.
In this first of your 3 careers, you predominantly represent plaintiffs. Could you talk a little bit about what that was like, who your clients were, and what you liked about that particular kind of practice?
I think you will find that most things in your career happen to you by chance. I mean, the moves that you make and where you end up and who you're working with, and you look back on it, think, you know, what a great blessing this was that the stars aligned and I got this job here with these people. I worked with Hank O'Neill and Manley Brown I was with Hank for 9 years before his death, and Manley for a total of 27 years before I went to the courthouse. And Hank had been representing plaintiffs, and so that was our practice. I loved it because it was a people practice. You sit down and interview new clients and find out what their problems were, and then after you had finished the interview and you had all the information, you could tell them that these were mostly people who'd been hurt or had a death in the family to deal with. And you could say to them, go home, get well, go home and look after your family. We'll take care of it from here on. And these are people, by and large, who are, many of them uneducated, certainly unprivileged, people who could not look after these legal issues without help. And so you got a good feeling. I mean, every day in law practice, you look for those good feelings. Not every day has good feelings. And a lot of it's stress and conflict and unhappiness. You have to look for those good moments, those happy moments. And being able to say that to a client and then take over that responsibility for them is a good moment. It's not to say representing corporations and big business and insurance companies isn't worthwhile, but it certainly is. And you can have the same kinds of good relationships with those clients just like you can with individuals. But in my experience, having done a little bit of both, I will tell you the individuals who have no way of looking after this themselves appreciate. You get a lot more thank yous, I think, from those individuals. So we enjoyed that plaintiff's problem.
Yeah, so their problems became your problems. They
did, yeah. You wake up in the morning, used to keep a pad by the bed and pen, and I could write in the dark. I didn't turn on the light and wake up my wife, but I would wake up and roll over and you think, you know, have I missed that deadline of this filing, whatever it may be, and you get up and write yourself a note and you lay in bed for 2 hours before you go back to sleep, wondering about that, wishing you could get up and just go to the office and look in the file and see if you attended to that. But that's part of law practice. You know, you have those stressful moments in the middle of the night.
I'm going to mention to you, by the way, that this is probably the 4th time this semester that Hank O'Neill has been mentioned.
Oh, really? That's wonderful.
One visitor or another.
Yeah, I'm glad to hear that.
Well, over 25 years of practice representing plaintiffs, I want to ask you about one particular kind of thing that you, I know, experienced. The students have just completed an exercise about civility. Several different contexts. They watched a couple of videos and then had to comment on maybe what caused the incivility and what they would do about it. I know you've encountered over your career a few such issues of professionalism and civility. I wonder if you can tell the students about one or two of those.
Yeah, I've seen them in the courtroom and out of the courtroom, so I'll give you an example of each. I've got a really good friend, lawyer and now former judge, who called me probably 20 years ago. We worked on a lot of cases together. And he called me and asked me if I'd help him represent the widow of a man in a life insurance claim. And I said, sure. We worked on the case for a time. We had a lawyer that neither one of us could really warm to. I mean, I was bent over backwards to try to make conversation with him, to try to find something of interest that we could have in common, to exchange pleasantries with, but he was just one of those. In fact, my friend in Tifton said, if you ordered a gross of SOBs, and you went down to the depot to pick them up one Saturday morning, and this guy got off the train by himself, you would have gotten your money's worth. He was worth 144 of them. He was that bad. So we got to a deposition one day, and my friend, who was sort of a Sherman tank kind of guy, I mean, there was nothing subtle about him and nothing, you know, retiring about him. He wanted to defend this deposition of his client, so we did it in my office, and I was sitting there, and we had a videotape going, because we thought maybe it'll tone down this other lawyer who is so aggressive and so rude and confrontational. So, but maybe this video camera will cause him to be a little easier to work with. During the deposition, the other fellow asked our client a question, and my friend from Tifton objects to it. So I don't understand that question. You have to rephrase that question. So he asked it a different way, and my friend objected again. Said, I don't understand it. I'm not going to let her answer it. And he said, well, this is the other guy. I said, well, frankly, I don't care whether you can understand questions, whether she can understand it and answer it. My friend blows up, well, she ain't going to answer it unless I tell her to answer it. And the other guy, I said, you said you have to explain it to me. So the guy starts to try to explain it. My friend said, I still don't understand that where you're going. You have to move on next week. He said, look, I've explained it to you in English. I can do it in German if that'll help. And my friend said, well, by God, I'll sprechen with you. And he stood up and they started shouting at each other in German. And the poor people were there trying to take it down phonetically. And finally threw up her hands and I said, time out. Let me take my friend and my client down the hall. So, but anyway, that I do have a videotape of that. I threatened my friend in Tifton from time to time that I'm going to pull it out and start showing it to people. But they got a little across the line there when they started shouting at each other in German and arguing with each other as they did. That's an example of, I think even my friend would say that was not a civil exchange.
Just to interrupt you for just a second.
Yeah.
Why do people act like that? I mean, it sounds to me from this description like this SOB was just that kind of person, and that can happen. But why do lawyers act like that when they're being lawyers?
Yeah, it ought not to be. It's sometimes it's personality. Some people are just bullies, you know, and they can't help themselves. Some people want to intimidate the other side. I've run into that. I remember a lawyer who was my dad's age, who knew my dad in Atlanta, and he was down here taking a deposition with me, and you know, before you start, you give the court reporter your business cards. She's got to have your address and correct spelling of your name, send you the bill and copy of the all of that. That's just routine. I mean, when you sit down, you hand her a card. This fellow, his name was Glenn Frick, he said, let the record reflect that Glenn Frick doesn't carry business cards. And I thought, oh, okay. I did something wrong maybe with my business card. But it's intimidation, I think. And, but I don't know that he could help it, and I just think it was ingrained in his personality. He was just as my friend would say, worth a gross of SOBs. It really was terrible.
Like that. Yeah. But I'm sorry, I interrupted you. You had another story.
In the courtroom, what I used to, and I don't think there's a course on this. I really think sometimes there ought to be, or at least a one-day session on courtroom demeanor. Courtroom manners, as Hank O'Neill used to call it. People who, well, let's take for example, plaintiff's lawyer objects to a question, stands up, makes the objection, and the other side turns to the plaintiff's lawyer and starts arguing his side of it, or maybe grabbing a piece of paper to go over and show the plaintiff's lawyer. I mean, and then the plaintiff's lawyer responds to him, and they are objecting and responding and bickering with each other in the courtroom. many times in front of a jury. And all of that is supposed to be directed to the judge. I mean, what Hank O'Neill taught me was the plaintiff stands up, makes his objection, and sits down. The defense then has the floor and has to respond to the objection to the judge, not to the plaintiff's lawyer. And then he sits down, and if there's a reply, then the plaintiff's lawyer stands up and he has the floor and makes whatever comments. Sits back down and the judge rules. Then the defense lawyer gets back up and presents whatever examination he was in the midst of when he was interrupted by the objection. That's the way it's supposed to go. It's not lawyers bickering with each other, arguing with each other over objections. That's not the way it's supposed to. And I remember one trial, a criminal trial, there was an objection by the state. I ruled on it, sustained it. The defense lawyer, of course, you could see the look on his face. He regretted it the minute he did it, but he turned around and took his legal pad and plopped it down on his table. And it had to have hit just exactly right, completely flat, because it went pow, and it started sliding across the table, and it was like time was standing still. I mean, everybody in the courtroom was watching that legal pad slide across the top of that table. It went by the defendant, who didn't dare reach out and touch it. I mean, he watched it slide on by. He wasn't going to touch it. And that lawyer, you could just see he knew he had really stepped in it. He should not have done that. And so I did call him up and we talked a little bit. But I mean, you can't do that sort of thing. I mean, you just have to be in control of your emotions. You know, this guy objected at another trial and kept objecting. He had a young lawyer who was giving an opening statement. He kept interrupting. And finally, and I ruled on the objections, and finally the young lawyer turned around and looked at me and said, "I would appreciate it if you would get that jack in the box to stay in his chair so I could finish my line. Come on up here, y'all, step up here." You know, and you don't do that either. I mean, you don't let the other side get under your skin like that. And that was an older lawyer who I think really was setting out. It finally occurred to me he was just trying to upset the chemistry, I guess, that the young lawyer was seeming to develop with his juries.
Well, in addition to why this kind of thing happens, one of the things the students are learning about and thinking about is, what do you do? How do you handle it when it happens? Now, you had an occasion when you were, before you went on the bench, where a lawyer strung you out on a deadline. And from that, and from Hank O'Neill's instruction, you came up with a way of dealing with the other side's incivility and lack of cooperation. Could you tell the students that story?
Partner came to me as an associate. So I've got this client. He's got to file an answer to this suit that's been served on him. It was a collection action, dispute about auto repairs that were done or not done, and whether it was Bondo or an original new fender, that kind of thing. I only had about 3 days, I think, in which to file the answer on that. And it turns out the plaintiff's lawyer was a classmate of mine. So I called him up and said, "Look, can you give me a couple extra days, I mean, just to the end of the week? I've got other things that I've got to deal with right now." So he said, "Well, I'll have to talk to my client about it." Remember that expression, "I'll have to talk to my client," because there's some things, if you're a lawyer, you get to decide and not your client. And whether to grant an extension of time in that context is one of them. But he said, "I need to talk to my client about it." I said, "Well, fine, give me a call back and I'll just move on to my other things." Well, I didn't hear from him the rest of the morning, so late that afternoon I called and left a message. Next morning I didn't get a return call, so I called again about 10 o'clock, left another message. She said, oh yeah, you got your message, but he had to go to this court. I said, fine, we'll just have him give me a call. Well, that afternoon, I called again. Well, yeah, he got it, but now he's over here. And the next morning, which was the morning of the last day, I called again. She said, yeah, he got his message, but he's, over here now. And so I just went ahead and canceled everything for the rest of the day, went to the library, did the research I needed to do, prepared the answer and the counterclaim, which is what was really requiring me to have this extra time I needed to do the research. And I went ahead and got it filed late on the last day. And to this good day, I've never had a return call from him, any of those messages. Well, it was obvious to me what he was doing. He was just stringing me along so that, I would be late filing the answer. Of course, I could pay the cost and reopen the default and all of that, but, that his client would get the benefit of being reimbursed. I mean, he was just trying to take advantage, I thought. And I wanted to find a way to, my attitude was to call him up, cuss him out, and, tell him how little I thought of him. And I mentioned it to Hank one afternoon, and he said, no, don't do that. I mean, there's no need to, he's your classmate, no need to burn bridges, we all got some history together. Do this, just put him on your list. I said, list? He said, yep, right up here, you got a list. He can move up, he can move down, but he never comes off the list. And I thought, that is a great way to look at it, because this way, he's on your list. You're gonna watch him next time. You're not gonna ask him for an extension. You'll go ahead and get it done, and then you'll work him to death on the next case. And, that's a pretty good approach. I mean, rather than calling somebody up and having some unpleasant discussion and chewing them out and then having to deal with that history every time you see him, you're going to be dealing with these people over and over, unless you're in a place like Atlanta. I think that's why, you hear examples of the incivility in big metropolitan areas, because I think the attitude is, I'm not going to see this person again, or it'll be years before I have anything to do with him again. A town like Macon, you go to lunch with them, you see them in church, you're in the Rotary Club with them, you go to Inns of Court with them. I mean, you don't have that kind of experience. But remember O'Neill's list. I think that's a great way to deal with those. And I've got, after now 41 years of law practice and being at the bar, I think there are 4, 5 people on that list, and that's not bad. So overall, I've had a good experience working with other lawyers.
But you could name them.
But oh yeah, I could sure name them to you. I sure could. And they can still move up or down, but they're
Never off.
never off the list.
One of the phrases that I remember from our previous conversation, you talk about, with those people on the list, you talk about observing the formalities.
Yeah.
What do you mean by that?
Well, we have a lot of rules in the law. You're dealing with people is governed by lots of rules. And, the formal observance of all of those rules, in my book, is really not necessary as long as the parties agree. I mean, you can extend time for doing things, you can waive certain things, just to make it easier for everybody. And my view of law practice is, in interaction with other lawyers, is you try to get along. I mean, you both have a job, you both have clients who have interests, you gotta both represent those interests. And you can make life easier for everybody if you can just agree to do things in a more convenient way maybe than the rules would require. And if you can't, then my expression is, you just observe the formalities. I mean, you do have the Civil Practice Act that governs how you conduct yourselves in litigation. And but if you can agree and make life easier for everybody, then that's what you ought to do. There's some people who just, for example, send out notices of taking depositions. I mean, they won't pick up the phone and call you and say, look, you got your calendar handy? What's it look like on this date or this date or this date? And see if we can get these depositions done. Instead, they just pick a date, their date, and they serve a notice of taking a deposition, and they leave it to you then to pick up the phone and call them and say, wait a minute, I can't do it on that date. But, you know, it ought to be easy to schedule depositions. I've had people that I've dealt with that you just about had to have a fight with them over picking a date for a deposition, which is unnecessary. So I had a lawyer one time who did not agree with the legal position I was taking, and for whatever reason, he just launched into cussing me out. Wait a minute, we don't have to have this conversation. He said, oh yeah, I'm fixing it, you gonna hear me? I said, no, I'm not. We can do it pleasantly on a professional level, or we'll just observe the formalities from here on. I'll deal with you in writing, and we'll observe the formalities of the Civil Practice Act. And then that's what I mean by that. I mean, you ought to get along if you can, but if you can't, there is always the Civil Practice Act that you can fall back on.
Which means you better know the Civil Practice Act backwards and forwards.
Yeah. Now, one thing I told my son, if you want to have an advantage as a young person over maybe a seasoned lawyer, it is to learn the Civil Practice Act backwards and forwards, because they apply to older lawyers just like it does to younger lawyers. And you get in litigation with people and you get in front of a judge, if you've got the book and page number, then you're going to prevail. That was another one of O'Neill's expressions, book and page number. Because he was talking about a citation to a case. He said every time you go to trial, you sit there for days just anticipating what the objections are going to be. And you do the research before you go to the courtroom. Don't get up and just argue a rule, a theory, or you have the book and page number. And the judge is going to be guided by that book and page number. That was part of putting together an examination of a witness, is you've got the questions, but you also anticipate the objections and put a little entry in there, and then the citation, and have a copy of that case. Because I used to go to the courthouse, this was before the days when you just run off copies of cases. You know, you carry a briefcase full of books over there with little pieces of paper stuck in there, so you've got the book and page number when the time comes.
Those books, those are those unwieldy things on the second.
Yeah, those things with a lot of paper in them.
Yeah, I'm not sure those good.
Yeah, people don't use them much anymore. Still love them.
Well, after all those years, the time came when you decided that you wanted to be a judge. And the opportunity came along. I wonder if you can talk a little bit about why you made that change, what you liked and didn't like about those 10 years, and then why you decided to leave a job that most people don't ever leave, except to retire.
Yeah, well, some people go there to retire. That's
Sorry to hear that.
I've heard that before too. I love practicing law, love representing plaintiffs and working with Manley and going off on trips, taking depositions, working with engineering experts and products cases and doctors and injury cases and malpractice cases. I mean, that was great fun to me. But after a time, and in my case it was 27 years, there was a sameness about it. I mean, you know, you've done it before. You've done it, some of it, hundreds of times before. And I, was at the stage in my career, age 52, when I was looking for something a little different, something that would be a challenge. I'd been mediating since 1988 as part of my law practice. So from 88 to 2000, through the year 2000, I was doing a lot of mediations, and of course that grew from 2 or 3 a year to 60 or so a year. And at the end of the day, it was such a great feeling to see people who had been in conflict with each other reach across the table and shake hands. Now, that's not such a big deal, maybe if it's an insurance adjuster and a plaintiff, nothing personal here, but I've also had lots of mediations where it was partners who had a falling out, sometimes law partners. But to see them shake hands, or family members in an estate dispute, shake hands and want to make an effort to renew a relationship that had really been tested through this conflict. It's a good feeling. I mean, I say you look for those happy feelings, those good feelings in law practice, and I got a lot of them from mediation. And I thought, you know, sort of an extension of what I'm doing in mediation might be being a judge, being at the courthouse, where you're helping lawyers resolve their cases. You're facilitating their handling of their clients' cases. And I've always loved the working with lawyers and talking about legal issues and how to find a way to resolve those. And I thought, you know, I will enjoy doing that as a judge if I ever get the opportunity. And if you ever meet somebody who's litigated cases who tells you he has never, ever thought about being a judge, or he's never had the thought, I can do that, he's lying to you. You can't be in a courtroom with a judge up there ruling on things and you trying this case over and over and over and not think about what it must feel like to sit up there instead of down here. And so I sort of felt like I was intended to do that, at least for a time. And I was intrigued by the idea of being a judge. And I thought I would enjoy it, and I did enjoy it. I mean, I enjoyed working with the lawyers. I enjoyed helping them fashion ways to, you didn't try everything. I still had the opportunity to talk with lawyers at pretrial conferences and hearings and help them find solutions to their clients' problems that didn't require a ruling. It required the signing of an order to make it final, but to help them find solutions. I was shocked to see that many times lawyers don't talk to each other until they get to the courthouse. I mean, that's just incredible to me. I mean, I could not understand that. You pick up the phone, you call the other side, you say, hey, look, we're both fixing to get over there and get tied up and our client's going to be spending money. What do you think about this as a solution? You know, give me a variation on that you think maybe we ought to consider. I mean, the idea that you would just gird yourselves for battle and go to the courthouse without ever discussing the possibility of resolving it is just, again, incredible to me. But I saw that time and time again. And they'd get to the courthouse, and then they'd find a way to work it out. Or they'd come in to see me, we'd talk about it, we'd have it resolved, and they'd prepare an order and go their way, and I'd take the next one and deal with it like that. Lawyers just don't talk to each other. What they do, and what I always hated to see, is they will email each other, and many times when they are unhappy with each other. And then it escalates until they're saying some really uncivil, unprofessional things to each other. Because if you get an email and you read it and it strikes you the wrong way, it sounds arrogant, you know, sounds like he's being demeaning to you and to your client, and unpleasant, and well, I'll show him. And you hit send, and there it goes. Well, he gets that, reads it, you know, he can tell the tone of it, and it's send, and there it comes right back in. Before you know it, you've got this nasty exchange, and then somebody says, judge needs to know about this. Copy the judge. Well, I'll tell you, that's something the judge does not want to get pulled into, is a petty disagreement between lawyers over issues that they ought to be able to solve themselves. But you see that, and that was a surprise to me, and something I really didn't like. Conflicts over discovery issues used to drive me crazy. I mean, I'd have lawyers who would file motions to compel over the failure of the other side to respond to something. I mean, that's the kind of thing lawyers are supposed to talk about. You know, lawyers are supposed to be able to work out those kinds of discovery disputes. And every now and then you're going to have somebody who's going to, you know, it's sort of a shell and pea game. They're going to, you know, hide the stuff. That's rare, but you read about those things. There's sanctions imposed on one side or the other. But you get motions to compel in probably a third of the cases, third of the civil cases you deal with now. What I always did is I'd write them back. I'd write both lawyers and say, it was always my experience in litigation that if lawyers will talk to each other face to face, then you can resolve discovery issues. And consequently, I'm requiring that the one who is the recalcitrant party, I'll call him, the one who has not prepared or submitted the response to the discovery documents, call the lawyer who is complaining and schedule a time when you can sit down and talk about each of these items of discovery that are an issue. If you can't resolve them, all you have to do is call my office and we'll have a hearing within 2 weeks. But if you can resolve it, as I think you will be able to, then just call my office and let us know we don't need to deal with this motion anymore. And I don't remember having over about 5 hearings in that 10 years I was at the courthouse on motions to compel after they got that letter, because they'd call and they would work those things out. But that's one thing that judges do hate to see, are motions to compel. That's on the resolve.
We're talking just a minute about on the criminal side.
Mm-hmm.
Hardy Gregory was here a few weeks ago and talked about, from his perspective, the difference between justice and mercy. And I was wondering if you could talk a little bit about your view of that as you were sitting as a judge in felony cases, and had to think about that big question of justice versus mercy.
Before I do that, let me tell you that because it sort of touches on this. I was not a judge very long before a new judge asked me for some advice. You know, so he was just coming on as a judge. And I thought there are really 3 things that I would say to a new judge. One is, remember that first you were a lawyer. And by that I mean, remember what it's like to be a lawyer. I mean, how many of you in here would aspire to be a judge? I hope some. Yeah, I hope so. We need good judges. But if you forget what it's like to be a lawyer, you become a tyrant. And I've seen judges do that. You know, they'll keep all the lawyers there all day long, doing pleas and waiting until their case is called. And then at 7 o'clock at night, pick a jury the next day. So they had jurors all day, all night, lawyers all day. I've even known a judge who wouldn't let them leave to go eat lunch, but would go in and eat a quick salad and then come back, and nobody could leave the courtroom all day long. Check in and out with the bailiff if they had to go to the, I mean, you know, that's just being a tyrant. That's doing it because you can do it, or because you're a bully, or whatever. I mean, that's, remember that first you were a lawyer. Second, in criminal cases, when in doubt, err on the side of mercy. That was the second piece of advice I gave him. When you're dealing with somebody's life and you're about to deal with incarceration, you better be really sure before you give them the ultimate kind of sentence, the heavy sentence. If there's any doubt, then err on the side of mercy. Plenty of ways to punish them, I mean, mercifully. And so, but the third thing is, and if you're ever going to be a judge, write this down. My daughter actually put it on a piece of a ceramic thing that she did. She did a gavel and, you know, painted this thing. But beneath the gavel it says, just rule. Because that is one of my dad's contemporaries and former law partner said to me when I went on the bench, that is the raison d'etre of a judge, to rule. It's the only reason a judge exists, and if you can't rule, you got to get off the bench. You need to get off the bench. Don't be paralyzed by the weight of the decision you've got to make. Just rule. I mean, thank goodness we have appellate court. I mean, there were decisions I made, opinions I wrote, and orders I signed that I had doubts about. But I took some comfort in knowing there's a court of appeals and there's the Supreme Court. And if I have missed the mark after all the work I've done to try to get this right, then somebody else. But if I don't rule, because I can't make up my mind, then nobody can go anywhere. You can't go to the Court of Appeals or the Supreme Court to get relief or to get a review. They can't do anything. I'm just, you know, I have just stopped the process by not ruling. So those three things I would say to anybody who wants to be a judge. Judging is the hardest job I ever had. You know, I used to hear people talk about, yeah, the judges got it made, they don't have to work, you know, they do the hearings, they set the hearings, they want to take time off, they take time off, they leave, go home at 4 o'clock. It was not that way for me. I mean, it was the hardest job I ever had, particularly the civil, non-domestic, because it is so heavy with paper, motions, hearings, rulings, just tough work. Criminal cases, making those decisions about sentences to be imposed. The hardest thing, I've said a lot of prayers before I sentence people. One of the first things I had to do as a judge, I'd been there 6 months, and it was my week to be the presiding judge, which is sort of the office judge, and everybody comes to the office judge to get TROs and things like that. Across my desk came an order from the Attorney General's office for me to sign setting the date and time for the execution of a man. Of course, I had nothing to do with his case. He'd been tried years before and been on death row for years and been through years and years of appeals. But I was the guy who, just by fate, by happenstance, was the one who had to set the date and time of his execution. He was the first one to die by lethal injection in Georgia, as opposed to the electric chair. And I went to the chief judge, and I said, I guess, surely this is a chief judge kind of thing, isn't it? He said, no, you're the judge, you're the presiding judge. You have to sign that order. So, I mean, just to give you an idea of the kind of thing, tried a death penalty case. We went 7 days straight through, and jury found him guilty, said there were aggravating circumstances. Their punishment was life without the possibility of parole. But I was prepared to read that sentence, sentencing him to death if that was their decision. There are probably 6 or 8 sentences I imposed that I will never forget because they were the harshest sentences the law would allow me to impose. This is in 10 years. Probably hundreds and hundreds and hundreds of pleas, 124 jury trials, most of which were criminal. But these were the worst. I mean, these people, as best I could tell, had no redeeming value. I mean, it's a terrible thing to say about a human being, but the crimes they committed, the crimes they had committed before the ones in front of me, were such that you couldn't allow these people to be back in the public, back in society. I mean, it was just that bad. And after prayer and a lot of thought, I gave them the maximum punishments, and I hope to goodness they are never out. But it's the other hundreds and hundreds. I didn't have any doubt about my ruling in my sentences. Those to me were easy sentences to impose. They're still weighty, but I felt so firmly that they deserved them. But it's all of the others that are so hard. And the guy who otherwise has lived a terrific life, but he got drunk one night and he killed somebody, either head-on collision or hit a pedestrian or something, fled the scene. But this is a good person otherwise. I mean, they've never done anything like this. You know, homicide by motor vehicle, felony. I mean, what do you sentence them to? 10 years? A year? Put them on probation? They've taken a life? I mean, that's not easy. I mean, don't ever take lightly what judges have to do, particularly in criminal cases. I see some judges whose conduct I don't particularly agree with in sentencing, calling people names and, you know, telling them there's a special place in hell for somebody. I mean, I've seen that kind of thing. I don't think that's appropriate. You still treat that person with some dignity. I mean, my view was, I'm not going to say anything to you I wouldn't expect somebody to say to me in like circumstances.
Judge, I've got lots of questions. I want to give students a chance to ask you some, but as usual, I want to give you the opportunity, if you have any words of advice, anything special that you think that these students ought to hear from you.
This is my Atticus Finch moment.
It is, whatever you choose.
I get about that because I love the book, To Kill a Mockingbird. And I always have viewed Atticus Finch as sort of the ideal, and even though he's a fictional character, and even though there is no perfect lawyer out there, I don't think that means we can't aspire to be an Atticus Finch. I mean, I think we all ought to aspire to be that kind of lawyer. And so for the 10 years I was at the courthouse, I made it a practice to give every law clerk and every intern from the law school a hardbound copy of that book with a little inscription in the front, 34 of them in 10 years, suggesting that they read this book every 5 years, at least every 5 years. so that they will continue to be reminded of and inspired by the kind of lawyer that Atticus Finch is portrayed to be. And I commend that to you. There are so many wonderful quotes in that book that you could do a seminar, and I'm sure people have, just on the book and Atticus and the things that he said, or Scout, like Jim said. But there was one quote that I wanted to mention to you that I wrote down. And it was at a time, I guess, after the trial, when Jim and Scout were really disappointed about the outcome, and their dad was, they saw him wander. I remember that great scene in the movie where they're up in the balcony and they all stood as Atticus walked out of the courtroom. Well, they walked home with Miss Maudie, and as they were coming down the sidewalk, they were sort of grousing about why it was their dad, you know, had to be in the midst of this thing and end up with this disappointment and being sort of an object of ridicule by some of the people in the community. And Miss Maudie said, there are some men, Jim, in this world who were born to do our unpleasant jobs for us, and your father's one of them. I will tell you, you are Atticus. I mean, we're the people who do unpleasant jobs. We're the ones that people come to when they've made mistakes, when they've done things that have embarrassed them, when they've done things that we want the rest of the world to know. I can remember a story about a prominent doctor in town sneaking in the back door of the law office to meet with Hank O'Neill about, you know, a second family that he had out in California that he didn't realize he had until he got a phone. I mean, embarrassing things. I mean, you know, the human foibles that turn into crises in people's lives. You deal with human weakness every day, and you try to help them through those times with dignity. And so just remember that we are Atticus.